the law power to provide for resettlement vests in the legislature of the state, and such person shall be deemed to be a citizen of India. This is the modification made in 7.
Mr. Zafar Shah, is it because part of the valley, a part of Kashmir remained in Pakistan, occupied? Was that the reason for this basis?
Sorry, I could not see.
Was the reason for this, as you are saying this is different, that a part of the state remained occupied by Pakistan? Is that the basis for it? Because there may be people who will be there and may be coming here. Is that the basis for this?
Not only that, there could be something more. Prior to 1947, there were many areas like Gilgit and other areas where the people of the state who were working under the king were transferred. I know a case that happened to me. They were transferred. An engineer was transferred to Gilgit. Then 47 happened. What do we do with him? This provided a method that if you want to come back, originally he was the citizen of this country. If you want to come back, you will do so only under the Resettlement Act, to be passed not by Parliament. In the case which I read to you, also it's the Parliament which is the power. Here, the power vests in the state legislature, that he can come back under this resettlement. So all those people, and important thing is, they shall be deemed to be citizens of India. Means they have not abandoned the citizenship of this country by dint of having been posted there or dint of being there prior to the partition of this country, prior to the part having been taken by them. Of course, that would include that also. The people who got separated, who are now with the Pak-occupied Kashmir, of course, the people who still have relationships in Kashmir, those are across the border, they are here. Those are the practical problems faced by the governments, social problems, people's human problems. They wanted to come back. Somebody wanted to die. I know many cases in Kashmir that happened in the High Court. They wanted to die in Kashmir, but they could not come. This Muzaffarabad road was opened. They wanted to come. It then got discontinued for political reasons. So therefore, this kind of a provision only enabled the state legislature to make the law. If they want to come, of course, subject to the conditions of that law. Whether you have voluntarily given up the citizenship of India, then you cannot come. But if you are by dint of a situation and the circumstances, you are stuck up in another place and you want to come back, after the things become normal, obviously a person cannot come when there is a conflict. When peace is returned, you can come back. Nothing is wrong with you, that you never intended to stay there, but because of certain circumstances. So I would say this kind of a power, all I am today indicating, Lordship, is the power, what we call as constitutional autonomy, which I have. It is in that context I'm saying, here I had the power to make the law.
Was large number of certificates issued just as a matter of
that was sometime that was made. I remember that, Your Lordship is. So the law of preventive detention can be enacted only by state legislature, not by Parliament. I must make one thing clear here, sir. Some of the laws may be sent as duplicate copies of the central laws. Just duplicate copies of this, maybe full stop, commas. But what is important is the power to make the law. It may be our state legislature could make the same law as it did, as this preventive detention law is applicable in the rest of the country. But the question is only a power. We say that this power exists only in the state legislature to make the law of preventive detention, and that's how Public Safety Act has been enacted in the state of Jammu Kashmir. It is that power which matters. Otherwise, laws may be the same. It's possible. Like we had Indian Penal Code, we used to call it. In the rest of the country, they called it Indian Penal Code. The difference was in the name. But the question was only a power. Our legislature could amend RPC, what we normally use called a Indian Penal Code, but obviously it cannot amend IPC, Indian Penal Code. Provision may be identical, provision may be same. But what is important to be considered, the power to make that law, the power to amend that law, the power to repeal that law. It is that power which gives us constitutional autonomy.
What I'm really trying to say is that under the 1954 CO, there were extensive amendments which were made to the adaptations or modifications were made to the Indian Constitution. There are provisions which were deleted, other provisions which were applied with modifications. In fact, interestingly, Article 136 was omitted.
Yes, 136 is omitted. So what I am trying to
say... So we get that point. We get what does that lead us up to actually?
What argument is this? That when we have a bird's eye view on 1954 order, There are some smaller matters, which are matters of internal administration. Then there are some fundamental ones. Like I read, for example, the proviso to Article 30, Article 3, that you cannot alter the boundaries.
Yes.
Now, that is a fundamental concurrence between the two governments. I read Article 7 with regard to the permanent residents. That's something fundamental in 54 order. So what I am trying to show is that there are orders which go to the very root of the matter and which continue to remain as they are till date. They have not been diluted. Subsequently, other provisions like 356 subsequently applied, 136 subsequently applied, but they are matters between the union and the state. But then on the broader parameters, the state continue to have its autonomy. That's all I am trying to indicate. By virtue of each and every, I have noted each and every article. It deals with what was the subject matter of the article in the Constitution, and how by the order of 1954, a certain position, especially for Jammu Kashmir, was carved out.
Mr. Shah, can you just, to sort of summarize, can you tell us on the eve of the CO of 5th of August 19, which were the key provisions of the Constitution to which an exception still existed in relation to Jammu and Kashmir?
So let us say Article 3.
So we can really summarize those, because that will give us the net position as on the date.
Very true, sir.
There's two ways of looking at it. We can look at the chipper way, or we can look at it from your perspective, which were the core which was still left intact, and which now the abrogation completely, sort of.
I need to watch with a full chart that what was the position on 4th of August 2019, even after application of these constitutional application orders. What was the position as on that date? That's what your Lordship wants to know.
Yeah.
Some of the articles which I read.
Every one of those provisions which was modified as on 4th of August 19, if you can give us the core to sort of buttress your argument that, look, despite the chipping away, this core had remained intact as on 4th of August 2019.
Very true. I can give that. We still had some autonomy. I'll give some fundamental. Let's say anti-97. We may not go that far also. I can give example of the best example, anti-97. Who had the residuary power? Who had the residuary power to legislate?
Interestingly, both the state list and the concurrent list were deleted in application to the state of Jammu and Kashmir. You'll find that, I just saw it a little while back.
That's what I think it is definitely.
Part 11, see page 16. Page 16 of volume 3, if you're in the same volume.
Yes.
It says in Article 246, the words brackets and figures, notwithstanding anything in clause 2 and 3 occurring, and clauses 2, 3 and 4 shall be omitted. So basically what happened was, in relation to the state of J&K, you had only the union list which was existing. Insofar as it applied to the state of J&K, the entire state list and the concurrent list had been deleted.
But subsequently, you should also see this.
Thereafter, maybe some items in the state list were brought in. Maybe the concurrent list was also brought in.
I think you also needs to give me some time. It is also subsequently changed in CO 66. This 246, which you also read, clauses 2 and 3, occurring in clause 1 to be omitted. That was the original one. 3 and 4 is also omitted.
So really speaking, we therefore take it, Mr. Shah, that we don't have to go through these articles to buttress your point, but your contention is that there was a very substantial degree of autonomy which was reserved to the state as a consequence of Article 370. That was not merely with reference to enacting laws, which we saw in clause 1, but it was also in relation to other provisions of the Constitution, which would not apply unless there was a concurrence of the state.
I thought I would indicate in specifically, one would be a general position of law, that there was a constitutional autonomy with you. What earlier it was, if I put it in terms of quantum, if it was something like 100 grams, but even then I retained 30 grams by the time it was 4th August.
Perhaps, Mr. Shah, what you can do is, maybe without us going into it right now, later on, even after your argument is concluded, you can give us the core areas which had remained for the state as on, the original constitution.
Specific area,
Right.
I can give.
You can give it to us as of, say, the 1954 order.
Yes.
And then you can give us what still remained with the state as on 4th of August 19. So we can have a comparison.
Yeah,
you can do it in 2 pages, that's all. Don't give us a very elaborate statement. That will buttress your point. So we appreciate it. That's all that we
I had done it my way. I had done it specific article wise. Each and every article, that's what I was trying to show. But if you also want me to give it writing, I will give that.
I think just, on a page, one page of the position as it stood in 1954, one page is the position as it stood on the eve of the abrogation. That will really support your submission.
But I'll give that.
So that we don't have to then read individual articles, unless there's something key that you want us to see,
What is important is this, as I said earlier. Why are we aggrieved of 5th and 6th? If nothing was with us. Why are we aggrieved? Why are we for 22, 25 petitions have been filed? There was something with us. I was trying to show what is that was with us. Otherwise, if there was nothing with us, it would not matter. It was an empty formality.
There was something with you, and there was an emotional context to it.
Whatever little sir I had with me as a constitutional autonomy, whether they could take it away.
That's why I said 2 things: emotional context and something which remained, actually also remained.
True. What I'm submitting is only, in response to only Chief Justice's observation, that you indicate only what kind of autonomy you had on that date, on 4th of August. I will certainly indicate that.
And even earlier, because that will support your submission.
Just what I was earlier, what I had in 54, is it also willing to go into the question that 54, what you got, and over the subsequent CO orders, what you lost at what state? I can take one by one your lordships on that. What I lost subsequently, but ultimately it ended up on 4th.
Yes.
But if what you say is on 4th, what autonomy
concerned
you had, indicate that, I will do that.
On 4th August,
I did have my
as
autonomy.
370 stood, what is that which were with you, which you have been denuded of by repeal of it?
So take it on the face of it, I can say so just from my heart without supporting it. Let's say, I was a permanent resident of the state. I had my own law. I had own privileges, own rights. Isn't that taken under? It's as simple as that. Just your lordship's knowledge. As simple as that. My state could not have been divided into union territories. Isn't that taken away? Honorable the Chief Justice says, you tell me the solid ones which you lost, not the other things appeal to Supreme Court or otherwise. These are few of the solid ones which come to one's mind. I lost that. I lost my legislature, lost the power to make the laws in respect of those matters where it had the power, maybe little power, but it had the power, particularly entry 97. It made certain laws, it made certain changes, but now that is also gone. Preventive Detention Act is also gone. We'll also see in the Reorganization Act how many laws have been repealed. Consequently,
Mr. Shah, to buttress your submission, we are saying something, which will enhance, which will further your submission. Just look at page 16 of volume 3, in case I don't know if you're using the same, we are on the same page.
I'll just have a look.
Volume 3, page 16. In Article 246, the words bracket figure
2 and 3, article so and so shall be omitted.
And clauses 2, 3, and 4 shall be omitted.
Yes.
In other words, Article 246, which recognizes the power of the state legislature to enact laws on the state list, and the power of Parliament to enact law on the concurrent list, was deleted in 1954.
Yes.
Now, just go to page 19, PDF page 19. Right. Now, in the 7th schedule, in the union list,
yes,
just go a little down, item 2, where it says entries so and so, the words interstate migrate, and entry 97 shall be omitted. Therefore, entry 97 is completely omitted.
Yes.
Now, go to the last clause of 22B. The state list and the concurrent list shall be omitted.
Yes.
So, the net result in 1954 was Parliament had the power to enact laws with respect to some entries in the union list.
Union list, yes.
The entire legislative domain of Parliament on the concurrent list was obliterated. And the state list was also deleted because the entire power of legislation, the legislative power, was given to the state legislature. This is the autonomy which you are saying,
Yes.
isn't it?
Yes, sir.